Hi, Jenny, and welcome to Ask a Pro with the ADU University. I am so excited that you're here. I have been looking forward to this for a very long time. So with me on this episode is Jenny Doling.
Doling.
Doling, thank you very much. So Jenny
Yep.
Doling, she is an attorney that specializes in bankruptcy and tax. And so I'll be able to, I want to let Jenny kind of explain a little bit more about what her focus is. But what I'm really excited about is because there's a lot of things that may pertain to you as a homeowner who is looking to bring an elderly parent that may have a lot of debt. They may have, they don't have any resources. And if you kind of having that parent or that family member move on to your property and all of the other sort of things that are kind of associated and related to that, Jenny is going to kind of give us a walkthrough and talk us through how you can kind of manage those, obligations and responsibilities. So welcome, Jenny.
Thank you, David. I appreciate being here. I'll give just a quick background. I am licensed to practice law in California and Nevada. I've been doing bankruptcy and tax controversy work, which is offers and compromise and things like that, for about 24 years, 25 years, I think we're going on now. I'm passionate about this area. I serve as the secretary and on the board of directors of NACPA, which is the National Association of Consumer Bankruptcy Attorneys. So I speak nationally on these topics. I have my LLM in taxation from the University of San Diego. And I find these issues interesting, very interesting, because we all know somebody or we've all faced one of these issues. And I'm excited to present today. Feel free to ask questions or save them till the end, whatever works best for everybody.
Well, thank you for that, Jenny. I think that, so for everybody who's watching us live, if you do have a question, just feel free to put it into the chat, put it into the Q&A. I'll definitely try to get to it as soon as possible. If you're watching this, whether it's a recording or you're listening to it as a podcast, there will be some link in there to the ADU University where you can kind of either submit a question to me, and we will have also on the website a way that you can kind of get in touch with Jenny if you have any sort of follow-up questions. And that's what we want to make sure that we're doing here at the ADU University, is providing you a resource to be able to help you kind of solve your problems. So I want to kind of dive into this novel idea about bankruptcy. And if you're, let's say that my father-in-law who moved into our ADU, now he was able to sell his house in India. And he had some money that was kind of, we could use towards the ADU, and we put a lot in the savings because he's 87 years old and we didn't want to take down his resources, in the event that he may need some assisted living. But let's say, as an example, he was upside down on a mortgage, or maybe he just had medical debt. And I know those are two really different categories, but if people are going, wow, I need to get mom or dad into an ADU, into my property, how do they even start the process of having to manage that really momentous thing?
It's a really good question. And I have a lot of advice to give concerning that. And where I want to start is, one, what is bankruptcy? Because that word usually generates terror and people think, oh my God, that's the last resort. When actually it shouldn't be the last resort. It's very easy to get a free consultation with a certified bankruptcy specialist like me. I give a half an hour free, and we talk about how that might be able to help you. The goal in bankruptcy is to preserve your assets and eliminate debt. And one of the things I like people to think about is not just in the aging years, but if you're 40 or older and you have a significant amount of debt, and significant is different for all of us. $40,000 is not a significant amount for someone making $300,000 a year, but it's an overwhelming amount for somebody making $40,000 a year. So that is all relative to your own circumstances. The reason I say 40 is because you can't get time back. So if you're not able to fund your retirement because you're paying minimums on credit cards and not getting anywhere, it's time to talk to us. Bankruptcy is not the end all that everybody, hears rumors, oh, you won't get credit for 10 years because it's on your credit for 10 years. That's not true. You can get credit almost immediately after a bankruptcy. And the reason is we live in a plastic world. They need you to borrow. That's how corporate America makes their money. So what I always try and say is let's look at what we can preserve. How can we do reasonable exemption planning? Exemptions are the laws that protect your property. And I've got a little segment later on about homestead exemptions and how important those are. But what we want to do is let's take David's example. If dad it has a ton of medical debt and he has equity in the home, why don't we discharge that debt in bankruptcy, eliminate it? Usually in your 70s and 80s, credit's not going to be a big thing for you. So even if it took you a year or two to reestablish your credit, big deal. We've eliminated that debt. And then you sell the house, because you can sell the house and then you can take all of those proceeds and not have a worry. And once that debt's gone.
So you discharge the debt, you take the debt, let's say he had $50,000 worth of medical bills. You discharge that in bankruptcy.
Yes.
So then you have to there's a process. And how long does that process usually take?
So on a straightforward Chapter 7 bankruptcy, which is the most popular to file, it's cheaper, easier, and quicker than any other chapter. However, there is a means test that you have to pass, and we have to look at how much equity do we have in the property. If maybe you have too much equity, we can do a Chapter 13 plan. A Chapter 13 is reorganization, where we take all the debt, we put it in one big pot, and we make one monthly payment to a Chapter 13 trustee. The trustee is appointed by the Department of Justice through the United States Trustee Program, and they're monitored. So you make that one payment. Those Chapter 13s can be 3 years long, up to 5 years long, depending on your circumstance. And every single case is different. I could have somebody that's only paying back 1% of their debt, and I could have somebody paying back 100% of their debt. You'd say, if I have to pay back 100%, why would I bother filing bankruptcy? Two very good reasons. There is no interest, there's no penalties. You just make the one payment. The date you file your bankruptcy, that date sets forth the claim amount. They don't get to add to it. The second reason that you would file a bankruptcy is because not all creditors file claims. In the Central District of California, which is the largest federal district court in the entire country, it encompasses from Santa Barbara down to Riverside, up to San Bernardino County, LA County, Orange County. It's huge. So in that district, about 57% of creditors file claims, 43% don't. So if you have a bunch of
explain what that means when you say a creditor is not going to file a claim?
So if a creditor does not file a claim in your case, they don't get paid. They can never come after you again as long as you get your discharge.
So you could say, let's say he has a credit card and it has $8,000 on it, and he goes into Chapter 7 or Chapter 13. And if that credit card doesn't say, here's my claim, then that debt is wiped off.
It's discharged in bankruptcy. Yeah. So that can make you in a Chapter 13 pay a heck of a lot less.
And is there any negotiations on the amount of money that's paid back, or do they, when they're doing, as an example, a 13, and you do have some equity in your house, are they going to typically say, if you owe 40, we want 40?
No, it's not up to the creditors. We don't have to negotiate with them. There are times that you might negotiate with a secured creditor over an interest rate or something like that. But general unsecured creditors, if they file a claim and it's a valid claim, they'll get paid whatever percentage the plan pays. So they might get 2%, they might get 80%. It just depends on each case. That is where we really get to be crafty. We get to see how much do we have to pay back? Do we need to go into a 7? Do we need to go into 13? Which is going to be the best result? And that's why you want an experienced bankruptcy attorney. Don't go with somebody who dabbles. You'll wind up wasting money. The case will get dismissed, and that doesn't help you. Dismissal is bad. Discharge is good.
And I think and you touched on something that I really am a supporter of, because we're all on certain social media pages, and you see all these people trying to bargain hunt, and that makes me cringe, particularly when you come to a specialist. And that's why we've really been spending a lot of time with the JADU University, is to really kind of educate people that, okay, folks, it's not just $150 a square foot to build your JADU. It's a little bit higher than that. And if you're
Yeah.
going that low, be able to ask, you need to ask the questions, because like law, construction is very complex. But also, but the thing about the practice of law as it pertains to bankruptcies, if you have somebody who may be charging a little bit higher on the hourly rate, they may spend a lot less time trying to advocate for you, but they're also going to be that much more efficient in their work. So even though it's a higher rate, it's just like any sort of profession, you're going to spend a little bit less time at it. The amount of money and time and anxiety that someone such as yourself could save somebody is also very hard to calculate. But this is a really key reason why I'm excited about this conversation, is that people may be just so afraid, one, of the complexities with ADUs, but then couple that with the fact they just don't know where to go but to deal with the family member's debt. And I think that's what's exciting, where you're like, hey, it's not a problem.
Yeah.
We can do this.
Yeah, and then think of it in the sense of the ADU. If dad had to pay off that $50,000 and he was going to do that out of the equity of the house, that's $50,000 less that you would have to invest in that ADU. That makes no sense. And I'm not advocating, don't go out and pay your bills. That's not what it's about. Your dad, when we're talking about people in their 60s, 70s, 80s, they've worked their whole life. They've paid into the system their whole life. Bankruptcy is there for the honest but unfortunate debtor. And that's what we have to remember. In the business world, Chapter 11 bankruptcy, reorganization, airlines, pharmaceutical companies, do you know what they say? They say, if you don't have a bankruptcy under your belt, you haven't reached your full business potential. They would never say that to a consumer. In consumer world, they want you to think it's the worst thing that could ever happen to you. It's not. It's a business tool. You are the CEO of your family. If your ship is starting to sink because you've got debt, are you going to keep letting it sink until the last resort? You use the last resort, and that last resort was something that could have fixed it while it was up here. You could have kept your retirement. You could have kept your equity. You could have kept your emergency savings.
And I think that's the part that I hope people, and if now who are here with us live, and welcome, thank you very much for being here.
Yeah.
And if you're listening or watching, this is, Jenny just touched on it, but I want to reemphasize this. Your mom or dad or family member may be thinking, I can't do it. I have this debt and I don't want to burden you with it. It's just like, okay, let's look at the ways to do that. So if they do have a $50,000 debt and they have $100,000 of equity in their property, you don't need to swap it out. You don't need to pay it off. It's just like, and the bankruptcy. So going back to, how long does it usually take if somebody were to say, yes, I want to do this? They reach out with you for that free 30-minute phone call and they say, yes, I want to retain you and I need some help.
So we do our consultation. I give an itemized fee quote right off the bat. And one of the things that I will mention about that, the way I look at this is I want you to know exactly what it's going to cost you from start to finish. I have no problem putting that in writing. I will tell you exactly what is excluded from that, which would be if somebody sued you in the bankruptcy court, that is, for fraud, that's a whole separate cause of action. It has its own case number, all of that. Where I see people not doing that is a lot of attorneys, and I hate this because it makes us all look bad, will give some lowball quote just to get you in the door, sign you up, and now you feel you're stuck with them. And then they start saying it's extra for the reaffirmation agreement on your vehicle so that you can keep your car and your car loan. It's extra for me to go to court with you. It's extra for this. And then they wind up paying more than what I told them it would be up front. So be very careful. Just like with anything, get a second opinion, get a third opinion, and figure out what attorney works well with your personality, what you like to hear about them, were they thorough in what they advised you, those types of things. So keep that in mind. As far as how long it takes, a Chapter 7 is usually 4 months from the day we file until the day you get your discharge. That's the court order that says, hey, creditors, you can never collect again, leave us alone. Approximately 35 days after we file the bankruptcy is when you have to appear for a meeting of creditors. The meeting of creditors was always mandatory in person. When the pandemic hit, the U.S. Trustee's office went to virtual hearings where it was either by phone or Zoom. Everyone is now being transferred to government Zoom. And the great thing about that is, in serving on the board of directors of NACBA, myself and my colleague advocated with the Department of Justice to keep those hearings virtual permanent, keep that permanent. And one of the things that I explained is, back to California having the largest federal district in the entire country, I had clients in Blythe on the border of the California and Arizona border and they had an 8 a.m. hearing at their closest federal district court in Riverside. They were driving down in the middle of the night, sleeping in their car for the 8 a.m. hearing. And that's assuming they had reliable transportation. So we use those things to put forth a reason this needs to stick around. Access to justice is very, very important. And they went permanent. So now you can be sitting at home. You can be sitting in your car on your lunch break for your hearing and do your hearing. And the way I do mine is I have my email up. So until the client's hearing is called, they can email me, because people start to panic. Many people have never been to court. So I answer questions right then and there. And then about 90 days later, the court enters the discharge on the paper. The real only reasons cases are kept open, and I won't talk about complex cases, we're talking mom and pop cases.
Right.
It might be kept open if there is a non-exempt asset that needs to be sold and liquidated. And you should know what those are going into your case. You know, if I say your car, we've got a $7,500 exemption, that exemption is applied to the equity. And it looks like we don't have enough exemption to protect the whole car. The trustee and I, or you, or the client, will need to make a deal on that. You can keep the car, you can keep making the payments, but the trustee might want $2,000. Great, if you're getting rid of $50,000, you got to pay $2,000. It's a really good deal. So that's how we handle those types of things. So Chapter 7, about 4 months. Chapter 13 is a repayment plan. So your case is going to be open for 3 to 5 years, depending on how long your plan is. If your income is above the median family income for your household size in California, you have to do a 5-year plan, unless you've got the means to pay it off earlier, but just know you'll be in a committed 5-year plan. If you are below the median income, your plan only has to be 3 years. Sometimes we stretch it out if that helps lower the monthly payment and helps you to make it and get through your case, because we want you to succeed and get to the end. But 3 to 5 on a Chapter 13 is just how that
And that
works.
brings up something that I had in my head, a 3 to 5 year on the Chapter 13. I was thinking that the 5-year would be a consideration given to somebody to have, let's say it's a payback X number of dollars. And if you have 5 years, you have a lower monthly payment.
It just depends on circumstances. So if I've got to pay, $100,000 back and I've got 5 years to do it, we're going to take that and we're going to divide it by the 60 months. If I don't make enough for that and I'm below median income, maybe my payment's going to be $300 a month and I'm only going to pay back $36,000. So every single case is different. I can usually give my clients a ballpark when I meet with them. And I always tell them a higher number. I want to give them worst case scenario, because nobody's happy when you come back and you say it's going to be higher. They're fine if they come back and you have a lower plan payment. So here's your worst case scenario. And if that sounds like you'd be able to do it, then we will move forward on this. And I will always do my best with strategy, with the legal knowledge I have, to try and get you in the lowest plan payment possible.
Thank you. I knew I was going to be learning a lot. And so
there's a lot of information here
between sevens and that. So that takes care of, let's say if my father-in-law has $50,000 in debt, he has $100,000 in equity in his property. He's going to be able to get the majority of that 50,000 discharged.
Mm-hmm.
And
it's
so
not all. Yeah.
And so that when he does sell that, there's not going to be anybody coming over after him for that equity.
Yeah.
There's no liens attached to the property. No. And it's just like, whew.
Yeah. It's a huge relief. I've been doing this for 25 years and my mom still to this day asks me, honey, aren't you stressed out? You deal with stressed out people all the time. I am in one of the very few areas of law where people are happy when I'm done with them. And it's a pleasure working with them. You can see, once you get out from underneath debt, you can see, oh my gosh, I can do this now. I can go and get the dental work I needed. I can buy health insurance. It's really interesting to see how people flourish after bankruptcy.
And I think that that's which is good that we're having this conversation. Because so few people really look at it that way.
Yeah.
I mean, I'm kind of discovering it through the ADU perspective of, as the example of like what happened, what's keeping, let's say the kids have equity, they own their house in Southern California. Okay, California, for more than a minute, you have equity.
Mhm.
And you want to put that at jeopardy with, people coming after, mom or dad and stressing that, because believe me, my father-in-law is 87 years old and he's a very proud Armenian
Mhm.
man. And he does not want to have anything that's going to make him look, less than responsible.
Yeah.
And I think that's it. The responsibility, you have debt, you have to pay it. And you said it really well. You've worked your whole life. You've been, a contributing part of society, and you are at your golden years. It's like, don't stress yourself out with that. And I think that that's important.
Well, your health and your happiness is far more important than the debt. I can deal with the debt.
Mhm.
That's, it's just money. It will
And
come
that's
and
what the
will
systems
go.
are for. Yeah.
Yeah.
This is what they are. So if somebody is, I don't know, because I have so many notes here, and one of the things I have on them is a homestead protection.
Yeah. This is super important. I want to cover this. I also want to cover how to title property so
Please.
that people don't make some mistakes there. But let's talk about what a homestead exemption is. There's two different things that you should be aware of. You can get a homestead exemption with your property taxes. That just lowers your property taxes a little bit. It's like a $7,000 off the value. So it'll reduce your property taxes by a little bit. That is completely different than the homestead protection, the homestead exemption that I'm going to talk about now. Homesteads have been around. They started in Texas in the 1800s. They wanted to get people to move to the state, and they said, hey, if you've got debt, if you've got creditors, come here, invest in a homestead here, and we will give you a homestead protection so that your creditors can't take your home. That was where that started. Most states have some sort of homestead exemption. Some states are really bad homestead exemptions, and there are a couple states that don't have one at all. And we are working on legislation for that because it's absolutely insane. You should not lose your house.
On a federal, not just California, but you're talking the country.
The entire country. So the homestead exemption, don't confuse it with it will protect your house. That's not how it works. It will protect a certain dollar amount of equity in your home. California's old homestead exemption prior to January 1st, 2021 was $75,000 for an individual. It was $100,000 for a married couple or head of household with a dependent child in the home. And it was $175,000 for elderly or disabled. That's terrible in California. Our homestead started in 1978. We have other ones, but the main one started in 78. And it was meant to protect the median family home. That was the point. Our homestead exemption did not keep pace with the skyrocketing home values. So in 2016, California Senator Bob Wieckowski reached out to me and several of my colleagues who serve on the board of directors and who have practices in California and said, hey, I really want to change the homestead exemption. And we said, we do too. So we pounded the pavement. We worked on SB 308, and unfortunately, we didn't get it passed. We were trying for a $300,000 homestead, did not get it passed. They should have given us that. I will say that. So in 2020, when the pandemic happened, Senator Wieckowski reached out to our same little stakeholder group again and said, hey, I think this is the time. Let's do it. I testified before the California State Senate. I testified before the California Assembly explaining how important the homestead is. We do not want another foreclosure crisis. We do not want neighborhoods uprooted, kids uprooted, not in the schools, and where their family support systems are, because many people live near family and friends to help each other with raising kids and things like that. So what we did is we went in and we tied the new homestead exemption to the median sales price in each county. It has a floor of 300. Yes. So it will move. We don't have to go back and legislate this. It will continue to move with the home values. There is a floor of 300,000 that is adjusted for inflation each year. That 300,000 is now 339,000. Why do we need a floor? The floor means that if you are in like Yuma County and your homestead or your median sales price is only 275, you're going to get it bumped up to that 339,000 floor. If you are in a higher county like Marin County or something like that, where you've got the median sales price is $1.5 million, they don't want this to be a mansion loophole where people can just go dump their money in a county and take advantage of a huge mansion loophole. So that's why we have the $600,000 cap. It is now this year $678,000, and change, but I'm just rounding it off, $678,000. And it keeps going up. Riverside County right now is $615,000. San Bernardino County is $475,000. That is an equity. So for example, if your house is worth $900,000, you owe a $400,000 mortgage, you've got $500,000 in equity, your homestead is $678,000. You have a $178,000 cushion because you're upside down. What that means is a creditor cannot force the sale of your home. And a creditor could be anybody who got a judgment against you. And there's another caveat. The homestead exemption is not applicable to taxing authorities like the IRS. The IRS can do what it wants, but it's not as ruthless as you may think. We can work on it if you've got IRS tax debt. Don't live like that. There's no reason. We can do an offer and compromise. But the homestead exemption is so important. One other thing people will ask, well, what do I do to get the homestead? Generally, you don't have to do anything. California has a statute that automatically gives you the homestead. However, last year, the Ninth Circuit, in a case that was unrelated to the homestead, the Ninth Circuit stated in passing, we don't know if you get the higher homestead if you did not declare a homestead exemption, but we're not deciding that today. Well, that made the hairs on the back of my neck roll up, and I was a little freaked out. So I have all my friends, family, clients record their homestead declaration in their county recorder's office. You can find that homestead declaration on every single county recorder's website, or you can call us and we will do it for you. It's a simple one-page form. It has to be notarized. If you're not comfortable doing it, the filing fee on it is approximately $175. And so we charge $250. So it takes care of our $75 of our time to prep it. And we can record it directly from our office. So that's something that we do for our clients who need it. I'm always big on, here's how you can DIY something if it's really something you can DIY, and a homestead declaration is. So get that done regardless, make sure you get it done.
And the homestead is going to stay on your property with that as long as you own it.
Yeah, the homestead's going to stay on there as long as you own it or until you declare that it's no longer your homestead. So if you have a rental property, you buy a new house and you're renting out your old home, you will want to record a new homestead on your new home. Otherwise, the homestead is on the rental property that you moved out of.
Do you have to, I don't know, turn that one off or just say it's no longer applicable there, or does that happen automatically?
It will happen automatically when you record the newer one. The newer one will take precedent over the older one.
Okay. This is fascinating. Can you give me a simplified version of where and how a homestead would protect somebody who owes money?
So if, let's say my minor child was in a car accident driving my car, now I'm getting sued. And let's say the trial is all happened and they have a $150,000 judgment against me. If I recorded a homestead exemption in Riverside County, and where I live, my homestead protection is $615,000. As long as I do not have more equity than $615,000, that judgment cannot force the sale of my house. It can sit there and it can accrue interest at 10%, the judgment rate in California, but they cannot force the sale of your house until there is a significant amount of equity. Now, there is a very good mechanism for dealing with judgment liens against our property, and that is bankruptcy. In a bankruptcy, we can do what's called a 522F motion. That refers to the bankruptcy code section 522F, and it allows us to avoid a lien that impairs our exemption. So anything that goes beyond the homestead there's a judgment lien and it's not attached to equity, I can get that judgment lien off, discharge it, and they're gone.
Because one of the things, and it jumped into my head is, and you, with the analogy of if your minor child was in an accident in your vehicle and there's this $150,000 claim. Let's say somebody's working on your property because they went to a local big box store, hired some people who are unlicensed, and they were doing, let's say, a new roof, putting on some shingles. Person falls off, breaks their neck.
Mhm.
We're talking serious bodily injury.
Right.
Who's on the hook for that? The homeowner. is.
Homeowner. Yep.
And could that be a $500,000 medical expense? It absolutely could.
Yeah.
And the sad thing about this is I've seen a lot of people, Jenny, where they just don't understand builder's risk insurance. They don't understand that they need to talk to their homeowner's insurance. And it's unfortunate that the people that think they're going to try to save some money. And I totally empathize with them that they want to save, and because they're looking at what
We all want to save money, but not at the risk of our home, our livelihood, our retirement, our savings.
And that's what it is. If you, and having the Homestead Act, the homestead, recording a homestead on your primary residence is going to protect you.
Yeah.
And it's going to add, it may not totally 100% protect you, but it's going to really give you a lot more protection than if you didn't have it. And it's only, you said $175 to do it directly with the county. It's a county, or it's 200 and I think 250 for you, 250 for you to do it.
Mm-hmm.
I'd never heard of that before.
Yeah. And it's such a cheap and easy thing to do. It's silly not to have it.
That's fascinating. Okay. Thank you for sharing with us a little bit about the homestead.
Yeah. Go ahead.
And you were consent, and I think I probably went out of order on the notes, but holding title and homestead. Homestead is not changing the title on how you hold your property. Then holding title is completely different. I know that one of my very first webinars, I talked to an estate planning attorney, because I love these deep dive rabbit holes when it comes to how you can kind of protect your assets, what you need to do in this crazy, state that we're in, who's trying to tax us left and frickin' right. There's ways you can kind of be intelligent about this. And yes, it is a little bit of work. It is a pain in the tuchus, but it is going to be so well worth it. So talk to us about holding title.
So holding title is really, really important. I just met with somebody the other day, and they said their realtor told them to add their son to their deed so they wouldn't have to go through probate. And I wanted to send a letter to this realtor and said, that is unlicensed practice of law. Do you know how much trouble you can get in for that, and how much danger you put these people in? And I'll explain why. If you hold title individually or with a spouse, you don't ever add someone to your deed that does not have an ownership interest. So take, for example, my client added their son to their property just so they would avoid probate. There are much better ways to do this. In 2016, California created a new deed. It's called a transfer on death deed, very similar to holding joint tenancy. Transfer on death deed gives you the opportunity to name somebody that you want that property to go to instantly without probate, without giving them an ownership interest in that property until you die. That is key, because what happens if son has to file bankruptcy? Now that's an asset of the bankruptcy estate. What happens if son gets into a car accident and gets sued? They can come after your house. We call it poor man estate planning, but I think it's ignorant man estate planning. And I don't mean that in a derogatory sense. It's that you're uninformed. And that's what ignorance of the law is. So what you want to do is, if it's important, you don't have a trust, you want to just make sure, maybe you're going in for surgery and you're like, oh my gosh, I don't have time to sit with an estate planning attorney and all of that. Do a transfer on death deed and leave it to the person that you want. It's a simple one-page grant deed, does not give them an ownership interest. You can take them off. You can change it at any time. There really is no danger with the transfer on death deed. Now, may not be, how do I want to say it? As creative as you would get in an estate plan. Maybe you wanted to give 1% to a charity and 1% to your son, things like that. You're not going to be able to do that on a transfer on death deed. This is just a very simple, you die, the property goes to son, and he doesn't have an ownership interest. Really
And that
simple.
makes a lot of sense, because
Yeah.
what that real estate in the example you gave, the real estate agent is advising their client to do something that really puts them at jeopardy.
It
As you
does.
said, something happens, and how many times we heard where the example is, well, I need to go on the loan because they couldn't qualify by themselves. So people kind of have this like, well, I need to sign on or let them be a part of because they don't have the equity, credit,
Yeah.
or, whatever the institution is saying that they can't qualify for. So the parents, loving them that they do, and that's wonderful, try to do something that, somebody's saying that they're giving them a suggestion. And, oh, hey, they're a professional real estate agent, they should know what they're talking about. No, take
No.
a second. And that you're really opening up Pandora's box of things that could happen. The question about you said that is an instant transfer. If they do the transfer on death deed, something happens, it goes immediately to the person who's named. Does that create some sort of a capital gains to that person's income, or does it just all of a sudden you own or have the title on this property?
So capital gains is going to depend on what the basis was in the property. Was it their primary residence? Some things like that. So I don't want to get into specifics about tax for that reason. But I will say, don't transfer before death to a relative or a friend or whoever your beneficiary is going to be, because now they've lost the step up in basis that they would have got had they received it on death. And that step up in basis is going to make a huge difference when they go to sell that property. So if you're taking the value as your new basis when they die in 2023, that's much better than what they paid for that property in 1963. So don't mess with transfers without talking to your CPA or tax attorney as far as transferring for death reasons.
Right. And I think in Burbank too, as my wife and I walk around and we see some of these dilapidated houses, and you just kind of go, wow, there's probably somebody who's a little bit older living in there.
Yeah.
And they may have been in there since the 1960s or 70s.
And they're sitting on a gold mine of equity.
Hundreds and hundreds of
Yes.
thousands of dollars. And their basis could be 200,000, 150,000.
Yep.
If they had a relative and they had a transferred on death deed, if I heard you correctly, that person passes, it's transferred to this other person, and then they get a step up in their basis. So it's no longer the 200,000 that they paid for it back in the 60s.
Yep.
It is now steps up to the $1 million, because that's what a POS house in Burbank is worth. $1 million.
Yeah. It's a
And so
huge
now-
error. If you do that and you can't undo it, the IRS is never going to let you undo that and go, oops, sorry, we made a mistake. No, it doesn't work like that.
So interesting.
When I say it automatically transfers, just like with joint tenancy or community property with right of survivorship, you're still going to have to take the death certificate down to the county and fill out an affidavit of death of the owner so that it gets into your name. But other than that, you're not going through probate.
And if somebody's kind of wondering, like, oh my gosh, this is good. You said it's just one page. It's a couple $100, a little bit more than that, but they still want some help and some guidance. Even though it's a small transaction, your firm can help.
Yeah, I won't do estate planning, but I can easily do that type of deed. If that's in our wheelhouse, I always stay in my lane. I refer cases out that are not in my lane. We have good referrals for estate planning attorneys. I would make sure the state bar will certify attorneys as specialists in taxation. I haven't done my taxation one yet, but I am a certified bankruptcy specialist. My colleague is a certified estate planner. What that means is that person has at least been practicing primarily in that area of law for at least 5 years. They have taken special education courses. They have taken a special test. It's like a little mini bar exam in that specified area of law, and the state bar will certify them. They also have to maintain more education than regular attorneys in that specialty area. So it's a super smart and good idea to go to a specialist. No attorney may hold themselves out as an expert or a specialist unless they have been designated that by the state bar. And you can find that on their state bar. Go to calbar.org. You can look them up. It will show disciplinary records. It will show specialties and things like that.
So an attorney says, yeah, I can do bankruptcy. They probably could help somebody with a bankruptcy.
Yeah. And people think
not...
bankruptcy is filling out forms. Filling out forms, that's the end result of all the legal work you've done.
And so the key takeaway is find, if you're just looking in your area of California or the country, look for somebody who does specialize and has a specialty. Now, you mentioned that that's on the California State Bar. How does it apply with other states in the country?
So I'm not allowed to practice in other states except for in the area of taxation, because taxation is before the IRS, which is federal. So I can take offer and compromise cases across the entire country, Guam and Puerto Rico. I don't have to be a specialist in that area to do that. I won't take their state, if they have a state debt, state tax debt, I won't take that because I am not licensed in that state. So
and let's say it's someplace like Florida, Texas, or state of Washington. Will their state bars, because every state has its own state bar, is that correct?
Yeah, that's correct.
And does every state bar offer the same level of designating an attorney as a specialist, the same way that the state of California does?
Mainly the same way. I don't know all the intricacies of each state, but most of the states, and here's why: they want the extra money. They want to charge you higher bar dues. So they want to have a specialty program, but they also want to make sure that people practicing them in that area are truly experts in that area. And they don't want you to be able to use that word, willy-nilly and just say, oh yeah, I've filed 5 cases. I'm about to hit 7,000 cases filed in my career. So I can do this in my sleep. And I don't, because it's very interesting. Bankruptcy crosses over into estate planning, probate, corporate law, tax law, criminal law. I mean, it crosses over into everything. So the smart attorneys that don't practice in bankruptcy refer it out because they know there's a lot of malpractice pitfall areas in this. So if you're not up to date on that, you've got an issue. Go ahead. I was just going to mention about holding title.
Yes.
The best way, honestly, to hold title and to make sure that you're passing down your property the way you want to do it is through a revocable trust. Revocable means you can be the trustee and you can change it at any time during your life, and you have to be competent also. Irrevocable means you cannot be the trustee, so you don't have control over your assets. The person that you put in charge, or the corporate trustee you put in charge, darn well better be somebody that you trust, somebody that has a bond, because we don't want you to be taken advantage of. An irrevocable trust, once it is set up, it cannot be changed. So keep that in mind. These are estate planning devices to make sure your property is passed down the way you want it. They are not really asset protection devices. So unless you have an irrevocable trust that is more than 10 years old, don't buy into these people that are charging $5,000 and $10,000 for asset protection trust, because I will tell you, I will pierce them. If I am hired by a bankruptcy trustee, it is not hard to pierce it. If you did it within 10 years, I'm getting in it. So don't waste that kind of money. There's other ways to do some asset planning and exemption planning.
And that's what you're saying. We're talking about the revocable and irrevocable trust. That's something that is an estate planning attorney. You'd say, yes, hey, you have that initial 30-minute, free phone call. Mm-hmm. You're going to very quickly be able to probably say, hey, yeah, you do have, or you don't have some debt issues that I could help with.
Yep.
But it also looks like you really need to, because they may have, and again, I used the example in Burbank. You have this person who's on, some sort of very limited income, but they're sitting on a gold mine of asset equity. Yeah. And the kids are looking at this going, okay, we need to just make sure that everything's set up, because there's so many things that can happen, when your parent passes, or if you're trying to do something to move them into your property. There's a lot of things you need to keep in mind. And because you're looking at, and this is what I think is hard, because with equity in a house, hundreds of thousands of dollars potentially, spending, 10, 15, $20,000 to properly get it placed, and I'm just pulling numbers out from the air, Jenny, I'm sorry, to really kind of protect it is going to save a world of stress and anxiety if something bad were to happen, and is going to protect those hundreds of thousands of dollars, whatever the equity is, from being delayed in probate or being at which is what we're talking about, sort of taken away. Because if mom or dad is looking, even though they have, all this equity in their house, but they still have this, they haven't been able to pay the debt. Because I think that that's not an unusual situation where they have all this equity, but they can't jump in. They haven't, and this is not very popular, but people do it. They haven't embraced a reverse mortgage.
Yeah.
They're not going to do that. They're just looking at being responsible and a proud person.
Well, and I'm glad you brought up reverse mortgage, because I do want to try and quell some of the rumors out there. Reverse mortgages were bad years ago. They would sign up the husband because usually they have a shorter lifespan than the wife. They would not add the wife to the deed. And when the husband passed, the wife had no income, no means, often no credit, because women couldn't even get a credit card until the 70s. But they didn't have any means of refinancing it out of that reverse mortgage, and they lost the property. Congress resolved that. So please don't get freaked out by a reverse mortgage. It can be a really good retirement tool. You can buy a house with a reverse mortgage. People don't realize that. So maybe your house only has $200,000 in equity. You don't really want to live there anymore. You need to downsize. You can take that $200,000, go buy a reverse mortgage, or go buy a house, downsize. Maybe it's $400,000, and you put the money down and you get your reverse mortgage. No house payment. All you got to do is pay your HOA dues, property taxes, and your insurance. It's a really good tool. So don't shy away from that. Make sure you do it through a reputable program. FHA.gov has some really good stuff. So does HUD.gov on that, where you're going to the sources that have the laws and they can put out that information. While we're kind of on the reverse mortgage thing, I also want to put out a website I have used for a million years.
Yes.
It's called canner.org, www.canhr.org. They have the absolute best, most helpful information for moving seniors into facilities, for elder abuse, tons of free webinars all the time. They're a nonprofit organization. They can get you to referrals. They can give you checklists for interviewing, assisted living facilities. Just a wealth of information. I love this site. So they can talk about if you've got to get a disabled spouse qualified for Medi-Cal and you want their name off the house, so there won't be a Medi-Cal lien. They talk about that. Those are really, really important things. So definitely visit that website.
And you touched on something that is very close to home for me. If you have, because my mother passed several years ago with Alzheimer's, and she had it for 7.5 years. And during the last couple of years, it was just a really, really big strain on my father-in-law, my stepfather, excuse me. So my stepfather was, again, very proud man of that generation who didn't want to get any additional help. But once he finally was getting that help, it was like this huge weight got lifted off of his shoulders. And we, for years, my sister and my brother were telling him, it's like, you need to do this. No, I can shoulder the burden. And I'm like, what? You're basically putting yourself in the hospital with the stress.
Yeah.
But I digress. So having to have that help with the canner.org, and you said it was C as in Charlie, A as in Alpha, N as in Nancy, H as in Henry, R as in Romeo.
Yep, .org. And I did I did answer the question, so I put it in the chat as well.
Thank you for that. And I think that this goes to using this kind of analogy of a reverse mortgage and having to look at this and using the example that an older parent has this huge equity in their home. Home may be dilapidated. That doesn't matter. Yeah, and they may have some debt because they're proud and they don't know how to really pay it because they're on a fixed income. Maybe that's all they have is their retirement and maybe some social security, and they don't want to ask for anything else, and they want to leave the money to their kids. That is exactly my stepfather. Yeah. I'm not going to draw anything more because I want to leave you something. I'm like, okay, but your carpet is 20 years old.
Right. So I say the same thing. What I told my parents, what I told my grandma had thought about getting new flooring, and she goes, no, but I want that money to go to my 4 girls. And I said, well, you're leaving them the house, aren't you? They're going to be walking on that floor. It's going to make the place nicer. It's an investment. But really, inheritance is what's left over. It should not be something that you're intentionally trying to meet unless you've got the means to do so. So stop that. You can't take it with you, spend it, and your kids, they'll be fine. They'll get whatever you've got left over.
And enjoy your life.
Yeah, exactly.
And
you worked hard.
I think that is it. One of the other categories that we have, and thank you for that explanation and the link to the canner.org, and giving a big thumbs up to considering reverse mortgages if that applies to you, because it is not the scary beast that it used to be. And instead of having to maybe go out and buy a house, you can pay for that ADU to be built in your kid's backyard.
Yeah.
It's a wonderful way to do it. The other category is risks to your assets.
Yes. So let's talk about that in the ADU sense. If you're going to do an ADU for a family member and they're going to invest in your property, are you going to put their name on title? What are the risks to that? What are the risks to the parent? What happens if the son and the daughter-in-law get a divorce? What's going to happen to their home? These are all things that if you take care of now in an agreement, in a written contract with each other, we call it a dissolution agreement. Not necessarily dissolution of marriage, but a dissolution of that property or that asset. While we're all getting along, let's have that drafted up. How will you value what mom or dad gets back if there's a divorce? How will you value what portion the son and daughter-in-law get to keep in that property if mom and dad want, if the dad, let's just say dad moved into the ADU. If dad moves into the ADU and still wants to leave something to the other siblings so that we've got an equal distribution, those are all things that I don't think that we think about ahead of time. And if you can address them ahead of time, you're going to stay out of litigation. You're going to keep your family intact and not have all of those issues. And you're going to minimize the stress and risk for everyone involved because it is stressful.
And I'm so glad you touched on that, because I'm spending this time and I always kind of think about, well, what happens if the parent has some sort of debt or obligation? But you also touched on something that is also very real life. Let's say dad moves into the ADU and the child and their spouse divorce. And if dad had given $100,000 towards it, or did a reverse mortgage and had put $200,000 towards it, having some sort of dissolution agreement is going to basically clearly outline certain aspects of what happens. The other part, I want to spend a little bit more time on that, but then going back to a situation that I'm kind of familiar with is because somebody, let's say that there's 2 sisters, they happen to be attorneys. One of them has the property, her husband, and she put all the money in for the ADU. Now dad's living there at 0 cost. And the conversation was to the other sister that there's this overhead that's being covered. Not only that, but in a Los Angeles community where rents are $3,400 a month, there is a sacrifice to a degree, because
there is absolutely
those things can be written out and spelled out.
Yeah, and if you do them ahead of time, you might spend $3,500 or $4,000, depending on how complicated the issue is, to have an attorney draw up an agreement that everybody's on board with, and that you can make part of your agreement in building the ADU and moving the parent in. Yeah, and then one thing I always hear is, well, they're going to get the benefit of the bump in value on the home. Well, it's hard to get that bump in value on an appraisal, to make it right. They're always going to lowball you on that. So it's not going to be this great thing right off the bat. Yes, in time, it's going to be good because you're going to have, maybe some rental income and stuff like that to show for it. But you've got those things. Then you've got the child that's not taking care of mom and dad, that's not, and I don't want to say suffering the impact, but dealing with the impact of an elder parent living on your property. It's not easy. So there's things like that where you have to talk about what the benefits and what the burdens are, what everyone believes is a fair resolution for that. And you have to memorialize it in writing, because nobody will remember what they agreed to. Memories go very quickly when it comes to money, and it's really sad to see,
Right.
but you can avoid that. You can avoid it. You can also use a life estate that says dad has a life estate in the property, meaning as long as he's alive, he gets to live there. And that life estate, if you go to sell the property, can be sold with the property, or dad can surrender the life estate. So there's things that can be done in that respect as well.
And that's interesting, because I think that that could be a very real issue. Let's put it in reverse. That, and let me ask this. Instead of a parent living in the ADU, let's say a child lives in the ADU. Could a life estate be drawn out that says for as long as that child wants to reside and is alive, they could stay in that ADU, even though the parents sold the home, the primary home?
Yeah, you can absolutely do that. And obviously that's going to diminish the value on the sale of the price, because, who wants to go buy a price where you get stuck with somebody's kid for,
Right.
the ownership
Exactly.
time of the property. But those are things that, can be negotiated. Everything can be negotiated. Another thought, and what I hear, and this always scares me, so I really wanted to make sure I mentioned this today. There's always talk about, oh, go form an LLC in Nevada or in Montana or Wyoming. They've got really favorable laws for LLCs, and then people can't take your assets. Please don't do that. Unless you have a real viable business and reason to put a piece of property in an LLC, do not do it without legal counsel. There are many reasons. You cannot claim a homestead exemption in a property that is owned by an entity. It is not yours. So we don't give homestead exemptions to corporations, LLCs, LLPs, things like that. So, and it costs money to have an LLC or an LLP or a corporation. You have to pay every single year your dues to be that. And you have to file tax returns, even if the only thing you paid was to the Secretary of State, the money to be part of that. So don't just jump on that bandwagon because you heard something on, on the TV show or something like that. Meet with a lawyer, understand the benefits, understand the risks, and see if make yourself educated so you can make an educated decision to see if that's going to work for your situation. Because for the most part, they're going to tell you it's a risk. Another title thing I do want to mention also, we talked about adding someone to title if they didn't have an ownership interest. But I want to talk about, what if they do have an ownership interest? How should the property be titled? Because joint title means that everybody has an equal share on that property. And if it's joint tenancy with right of survivorship, when one dies, now the two remaining survivors have it. What if that wasn't the goal? What if you thought husband and wife and dad each had a 1/3 interest? That doesn't happen on a joint tenancy deed. When dad, or when, say, husband dies, now wife and grandpa own 50-50. How did grandpa now get a bump up when he was only supposed to own 33%? So tenants in common is the deed that we use in California, where you can have unequal shares and where you can have percentages, and you put that into the deed. And you can have husband and wife have joint tenancy between the two of them, but between all three parties, they have a 1/3 interest and 2/3 interest. Those are really important things. And I can't tell you how many people in the last 25 years have come to me and said, well, that's not what we agreed to. Well, that's what you put on your deed. And that's what happens when you try to be a Google lawyer. You get Google advice, and you get really messed up.
Oh, come on, Jenny. It's not Google now. It's going to be your
It's
AI, your ChatGPT is going to answer your question for you. The ChatGPT attorney. That's what it said. So let's see how that works.
And I'm a techie, so I've been messing with ChatGPT for a long time. I will tell you, it cannot cite the right case. So we put it through the ringer at USD, at the University of San Diego, and we put in facts of cases. It could find the right factual background, but it gave the wrong case site. There was a lawyer just disciplined, said he didn't look at the sites, and the judge disciplined him. He was sanctioned. It was like $10,000 sanction. It was really bad. So you
Well, can't he
can't
just go
trust
ask
it.
ChatGPT for the 10,000 for being wrong?
Nope. And it's not confidential. So attorneys should not be putting in client confidential information.
That is, yeah, that's kind of horrible.
Terrifying.
So the part of this, I think, is we keep repeating it, and so I'm sorry, but I want to drill this
Yes.
home. Is that talking to the right person, even though the right attorney, the right consultant, is critical.
Yeah.
To be able to see your whole landscape of things, because there's no one right simple answer. Everybody's kind of like a snowflake. You're all very unique, and I think that's why it's important to be able to take the time and energy and effort to understand just what it is. Because does your parent, did they contribute towards the construction of the ADU?
Right.
And there's so many sort of things like, okay, if they do pass and they've left money, what kind of things would go towards the kids that had dad living there or mom living there. So those are things that I think are really important. And you said the best thing to do to kind of memorialize that is what again?
You want to get an agreement. I call it a dissolution agreement. Other attorneys might call it something else, but we're all talking about the same thing. The other thing I want to say as well, if you are upfront with an attorney and you say, I only have $5,000 to do whatever I need to do as far as legal planning on this, is that something that you're able to work with? Then the attorney knows I have a budget and I can't exceed that. And they can tell you, I can do X, Y, and Z for that. You're probably in the future going to need to take care of A, B, and C when you can afford it. Those things, you can do that. And if you are going to a reputable, experienced attorney, you can pretty much trust that they're going to give you the right advice. I tell people all the time, you know what, you don't need me. You're
Right.
in good shape here. And they're so grateful to hear that and to have that. And what I always say is that's good karma. What it does for me is it shows that I educated them on their situation. I told them they did not need me. They were happy with the advice they got, and they are going to remember that, and they are going to refer me business. So I never think of that as lost income or, lost money. If I can't help you, I'm going to refer you to someone who can. If you don't need me, I'm going to tell you that. That's why it's imperative to go to somebody that is reputable, that's been around a long time, that has no disciplinary record, that you've been referred to, you've checked references, you have, 2 consults with someone else, and you compare which attorney is going to fit in my situation the best and give me the best value.
And I think that's a really great advice. A question that just came in. Let's say somebody files Chapter 7 bankruptcy. How long do they have afterwards to wait before they can apply for a reverse mortgage?
So reverse mortgages are not credit-based. That does not mean you can have hundreds of thousands of dollars in debt and go get a reverse mortgage, because their goal in a reverse mortgage is a negative amortization. It means that every single month, the interest is being added to the loan. So they're going to get paid a lot once the homeowners pass. If they have to sell that home in a forced sale, then they're not going to get very much money, and that wasn't a good deal for them. So that's the know-how behind what's going on there. However, if you get a reverse mortgage, and let me see how the question was worded again. I want to make sure I answer this just right. How long do you have to wait to apply for a reverse mortgage? So after a bankruptcy, you are debt free. So the only debt that you're going to have hanging out there is if there was a non-dischargeable debt, maybe for fraud or student loans, which I have student loans I want to address with you guys, because it's really important for our senior community. So if you've got some kind of non-dischargeable debt, that will survive the bankruptcy. Also, if you have secured debt, your mortgage, if you're keeping the house, you got to continue to pay the mortgage. There's a lien on it. If you want your car, you keep paying your car. They don't want your car back. They just want your payment. That's all. So you've got those couple of things. But if all of your unsecured debt is gone, you don't have to wait to apply for a reverse mortgage. You can get a reverse mortgage. In fact, you can get a regular old FHA loan 12 months after your bankruptcy discharge, as long as you have the 3.5% down, as long as you have the sufficient income to make it, and as long as you've not incurred new debt or defaulted on debt that you have. So it is not the end all that it used to be.
And thank you very much for that question.
Mhm.
And for that answer. I
Yeah,
think that's
good
really important.
question.
It was. The moving on, because I know that we're
Mhm.
now past the 60-minute mark and we're coming in towards the 90, and that's all I want to keep you because
Fine, I love this stuff.
I do. I absolutely just appreciate all of this information, because being able to have a conversation with somebody about something that I'm living in, and
Yeah.
also, helping people try to say, here's how you answer this question, because
Yeah.
what's in front of us right now is more homeowners are having to deal with these very large financial
Mm-hmm.
transactions of building an ADU, whether it's a loan, a HELOC, the cash out of the retirement, or they're doing something with their parent. These are huge transactions. And so now it's kind of forcing this issue to tens of thousands of people, on the West Coast. And now it's going to be sort of broadening out through the entire country, because people are understanding that they can kind of tap into their backyard property to build. And I think that the federal government is really looking at this going, yes, we
Yeah.
want you to be able to do this. So there's going to be a lot of really good things for people to consider about building an ADU or doing something on their property to provide some additional housing, because we desperately need it. The protections and the coordination are super complex.
Yeah, and critical.
It is, and you have to pay
Absolutely
attention.
critical.
You do have to pay attention. That gets us to the other thing that was on your list, is like, how do you then sort of, I love, umbrella policies, trust,
Mhm.
entities, dissolutions. We've talked about that, but how do you, in your perspective, minimize risk?
I think the easiest thing is buy an umbrella policy. It really is. They're cheap. If you think, even if that policy is $2,400 a year, $200 a month, and you're renting out your ADU, you are at risk if something goes wrong. What happens if they start a fire? What happens if they get injured on the property? Who are they suing? They're suing you because you have assets. They know you have assets. They're looking at them. And so if you get an umbrella policy, $1 million policy, $1.5 million, $2 million, whatever suits your needs, it's so worth it. Because if you think about it, would I have spent $200 a month to avoid litigation, to avoid the stress and heartache and tears, because there will be tears in litigation, I guarantee it, and to have an insurance company come in and write a check and be done? You would have paid it. And it's just a cost of doing business. It is a cost that you can, put on your taxes. Do it. It's the simplest, cheapest, easiest way to do it. The other thing, trusts and entities, like I already said, there's some drawbacks there. There can also be some benefits. So if you don't live on that property, that's probably a good property to hold in an LLC by itself, not with other rental properties. Hold it in that LLC by itself. Sure, there's going to be added costs to it, but guess what? If somebody slips and falls, they can only go after the assets in that LLC. They can't go after the assets in your other LLC. So really, really important to treat different properties differently. But again, do not do that to your primary residence, because you lose a ton of protection. You lose the capital gain exclusions, tax advantages, things like that. So watch out on that.
So I'm going to throw you a curveball.
Yep. Let's hope I can answer it. If I can't, I will always tell you.
So talking about, if you're renting out the ADU and somebody slips or falls or does something, and you have an umbrella policy, but let's say that the ADU was not built to the health and safety codes.
Yeah.
Let's sort of say, because what is the big buzz that has been around for years is a tiny home. And what's really kind of gotten me interested in the education aspect of construction and accessory dwelling units has been driven a lot by the misinformation that's around a tiny home, because it's used in our lexicon and the vernacular as something that just is small. But if you look at it and you kind of dive into it a little bit more, it's only for occasional occupation.
Yeah.
Habitation. And it is not something that you can live in permanently. So if you look at these small, little, cute, little charming units that you can basically pull behind your truck and attach them to your hose and maybe connect it somehow to a sewer system, you really don't need a permit to install it. Would in your opinion, an umbrella policy cover the homeowner if somebody slipped and fell in something not designed to be lived in continuously and they were renting it out for year-round habitation?
Be careful, because those policies are very specific in their exclusions. And sometimes you may not understand the wording of an exclusion, and that's something that you should definitely go to an attorney about and have that explained to you. Please don't rely on the insurance agent. I'm telling you, they sell the policies. Most of them do not understand what's in the policy. They can tell you, generic overviews, but I know when I've asked my agent some questions, I've got some really funky answers about it that I'm educated in the law, and I thought that doesn't sound right. It may have sounded fine to somebody who's not educated in the law.
Mhm.
So you have to be careful on that. You could wind up with a voided policy altogether.
And if you're spending something like you
Yeah.
said, $2,000 a year on that, a couple $100 a month, thinking that you're just going to pass on the cost to your renter.
Yeah.
And you only spent, $80,000 for your tiny home ADU, and it goes to all of a sudden there's something that happens and is voided. Guess what?
Yeah.
You're
Well, and none of us should be, have rose-colored glasses on when we're dealing with insurance companies. What is their number one goal? Not to pay claims. It is not to pay claims. They are not your friend.
no, they are not. So what would be a recommendation for somebody who is thinking about doing that? They want the shortcut, they want the savings, and they don't want to spend $250,000 or $350,000 for an ADU. They want to spend $50,000 for an ADU. My opinion and thought is that they're not going to be able to try to find their way some insurance coverage it's not going to exist.
No. It's not going to exist. And you have to remember with those they're basically an RV. If it can be towed, it's an RV. And we're talking auto insurance when we're talking about that. We're not talking the protections that you get in a homeowner's policy or the protections that you get in an umbrella policy. So think about it realistically. Sure, it would be nice. I mean, I could go pick up a little 20-footer for, 40 grand or whatever and stick it in my backyard. That is not what it was meant for. And there are reasons for that. There are health and safety code violations you could get for things like that. You don't want to risk having liens put on your house. You don't want to have to risk going to litigation because somebody sued you on it. And now you're stuck in 3 or 4 years worth of litigation, running up, really taking your entire retirement savings, all of that, paying a lawyer every month. That's terrible. It's terrible. And the civil courts in California and around the country, this is not just a California plan, they are still behind because of COVID. Criminal trials have priority. We've seen a lot of those have to be dismissed because they didn't meet the speedy trial requirements. So that's scary. So guess who's lingering in the background? The people with civil cases. So even trying to get your case adjudicated is not good.
And I really appreciate your comments on that topic, because that's one of my big banners that I run around with, going, hey folks, you shouldn't do it.
I do too. And I think people think, oh, that's just because you want the money. It's really not. Do you know if somebody hires me to do a bankruptcy because they either tried to do it on their own or they hired somebody who dabbles in it, it will cost them 3 times the amount I would have charged them to do it right the first time to try and fix it. And that's only if it's fixable. Some cases cannot be fixed. And I think
So
that's the
they
same
tried to
thing
do it
in
on they tried to do it on their own.
Yeah.
They're like, oh, I'm now kind of I can't get out of this. I don't know how to get out of it. They come to you and you're having to unwind it.
Yeah.
If
I can. Once you're in a chapter 7, you're in it. You don't get back out. A chapter 13, you can voluntarily dismiss. You're driving the bus in a 13. In a chapter 7, once you're in, you're in. So it's a dangerous thing to mess with if you're unrepresented or you're represented by uneducated counsel.
And thank you for that. So can you just kind of share with us a little bit about where your service area is, who's a good client, and if they were to send you, say, hey, yeah, I want to reach out to you, I want to get some more information, they do the 30-minute, are they going to be working with you? Do you have a team of people? what is your firm setup like?
Yeah, so let me give you a little background. I do every single one of my consultations myself. I don't have a paralegal do it. I have fantastic paralegals. Isabel has been my bankruptcy paralegal for 15 years. April is here. April's been here for 3 years. Amanda's been here for 8 years. I have a really good, competent staff. However, by law, they're not allowed to answer a legal question. Only the attorney can give legal advice. They know the generic stuff, they know a lot more than that, but they know they're only allowed to tell clients, hey, we need these forms. I need this information. I'm going to review your case with you. And then it's going to go to the attorney for legal work. All legal questions go to me. I answer all of those. So I am very hands-on. And I think it would be scary if I wasn't, because things can happen. I'm the one that had the education, went to law school for 3 years. So that's how I handle them in my case. I give a free consultation if the client fills out our client questionnaire. That questionnaire allows me to give them specific advice tailored to their situation rather than just a generic overview. If they don't want to fill out the questionnaire, they can pay $350 for the consultation. And that's how I deal with that in my office. I serve all of California for bankruptcy. I'm primarily in the Southern District, which is San Diego area, and the Central District, which is all the counties I had mentioned earlier. That's where I have filed the bulk of my cases. I do get called as an expert. I've been up north, the Redding area. I've been to Frisco and Oakland area, filing cases there as well, or being called as an expert witness on bankruptcy. So that's kind of my
so
overview.
San Diego County, Riverside County.
Yep.
Do you go into Orange or LA?
Yep, all of that is the Central District. So I do
Okay.
the entire Central District and I do the entire Southern District, which is Imperial and San Diego County. Now for tax, I can handle tax cases across the entire country. Although, it's kind of hard to find me if you're in Louisiana or something, unless you're referred. But I can handle tax matters because it is the exact same IRS code across the entire country, and we are allowed to represent clients across the entire country. So those are my two areas of practice. If somebody does not qualify for bankruptcy or it's not in their best interest, I do debt negotiation, where we negotiate settlements with the creditors. And that's not my favorite. It takes the longest. There's tax disadvantages with that. If you you owe American Express and you owe them $10,000 and you pay them $5,000 as a settlement, the $5,000 dollar portion that they have to write off is called cancellation of debt. They will give you a 1099 and you have to report that as income on your tax returns.
I did not know that.
Yeah, it can create tax issues. Now, if you're not making a lot of money, that little bit is not going to, create a big tax debt. But, I've settled $1 million cases where there's a big cancellation of debt issue. So those are things, that's anything debt related, insolvency related. That's my area, tax debt, all of that. It's the only areas I practice. I don't dabble in other areas. I would never do my own estate plan. I would never do someone else's. I know about them. I, obviously learned about them and I try and stay current, but I stay in my lane. I refer those out to my qualified colleagues that can handle those.
And when do you ever suggest to people that may have medical debt to talk to somebody who may try to get some of that medical debt written off or forgiven or kind of some of it erased before going to the BK?
Yeah, so you're not before going to the BK, because if you can qualify for the BK and wipe it all out, it's much cheaper, easier, and quicker. Just do it. If you don't want to file a bankruptcy or it's not the best option for you, negotiating that medical debt is key. And you don't need anybody, you don't need an expert to do it. You can call them up and you can say, look, I'm on Social Security, or, I'm making low wages, whatever the circumstance is, and negotiate with them. Just know they're not going to give you what you want right off the bat. So you have to be in it for the long haul. I always start negotiations down around 20% because it's very rare you get it any lower than that, because debt buyers buy them for 10%. So they at least want to make 10% on it. They're hoping to make the whole thing. So those are some ideas there. The other thing that I want to mention, and this is brand new, it is not a change in the law, but it is an extremely important thing that I think everybody needs to be aware of. When we think of student loans, we think of new graduates coming out, and why should they get, why should they get student loan forgiveness? That's terrible. The majority right now holding the most student loan debt are on already or heading into Social Security years.
Wait, so wait,
And
repeat that again?
yeah, the majority of student loan debt held right now is being held by those who are 50 and older, either Parent Plus loans or their own student loans, or they've co-signed on student loans for their kids. It is the student loan debt bomb crisis. Student loans stopped being dischargeable in bankruptcy in 1994. If you watch Fail State the movie, and it's www.failstatemovie.com, it's a documentary by Dan Rather and some very important educated people on student loans and the student loan debt crisis. It shows you how making that non-dischargeable made the entire tuition and student loan crisis blow up. It used to be affordable. So that's just a background thing. But what I want to say about it is, if you go into retirement with student loan debt, did you know they can garnish your Social Security? Social Security is supposed to be totally 100% protected. The only people who can get it is the
Untouchable.
IRS. It's student loans can get it. So it's really bad. We have fought for several years for another option. There's actually a bipartisan bill to restore dischargeability in bankruptcy. That does not mean the second you graduate, you can walk in and get qualified to discharge your student loans. And remember, there is a means test in bankruptcy, meaning doctors that are making, $300,000, $400,000, $500,000 a year, they're not going to qualify for student loan discharge. So we have to kind of take out, erase the uneducated talk about student loan dischargeability. We have now, even though this bipartisan bill, it's probably the only bipartisan bill sitting in Congress right now, even though it has not passed, it keeps getting some more and more traction. In the meantime, we have worked out with the Department of Justice and the Department of Education a stand down policy. If our clients in bankruptcy meet this criteria, and it's long, they can file an adversary proceeding in their bankruptcy to get a hardship student loan discharge. It is the first movement we've had on this since 1994. And we have people that are really suffering. They can't buy homes, they can't retire, they're still servicing this debt. There is now an option. I have people who are trying to say, we want my mom and dad to, move into the ADU, or our son is living here, is never going to be able to move out so grandma and grandpa can move in because he's saddled with student loans. That type of debt, if they meet this criteria, what happens is we file an adversary proceeding in the bankruptcy case. That is a separate case. It gets its own case number. It is a separate cost that's running between $3,500 and $4,500. In that, if we've put forth all of the documentation that the DOJ and the DOE has asked for, they will stand down. They will not oppose the discharge on it. They will stipulate to dischargeability. This is the first movement. It just happened. It just happened May 1st. So
walk me through it one more time, because this is really big news.
It's really important, especially for people who've been saddled with it and suffering. Maybe they had a bad school and their degree was basically useless, but they're having to pay $100,000 back on it. Eliminate that debt.
Is it separate from the BK proceedings, or is it in conjunction with?
It has to be in conjunction with the bankruptcy, because you do not get to do an adversary proceeding unless there's an open bankruptcy case. So how I do it with my clients is I say, okay, we meet, we go over what the cost of your regular portion of your bankruptcy is. Here's what that is. Within 60 days of us filing that bankruptcy, we have to file the adversary proceeding. And that's the separate case. They will be quoted what it is up front, depending on the amount of debt they have, who they owe it to, how many loans there are, what the complications are. It could be very simple, and it could be a $3,500 one on up to $5,000. They're averaging between $4,000 and $4,500. But not a bad price to pay for getting rid of the debt. And if you can, maybe borrow that from mom or dad or something to pay that, that's a whole lot easier to pay off than, the big amount. And for elderly clients, it's extremely important. We have people living on fixed incomes. We have outrageous interest rates going on right now. We have a lot of factors that everything is going up around everybody. And it's hard to service that debt. It's hard to live under that weight. So there are options.
And it was the Dan Rather, you said Dan Rather?
Dan Rather, failstatemovie.com. It's so interesting. I think everybody who watches it kind of goes, oh, so that's how that happened. It wasn't just that people were willy-nilly trying to run up, hundreds of thousands of dollars in student loans. It's very interesting to see all the background information on it.
So one of the things that we do at the ADU University, the website, is we have these little short, I call them commercials for the webinars. And with our resources page, we're going to be offering, it's like, hey, if you're thinking about, bankruptcy, or you're thinking about, having to take care of, student debt, there's like 3 or 4 little commercials I think I could probably do from this webinar, because they're all so individual and they're also specific, because the normal person is not going to think BK, oh, I can get rid of my student loan debt, because that's usually not been touchable.
Well, and that's what the code says. 523A8 says student loans are not dischargeable. So we've got this little path here, and it could change with the change in the administration. So people who are interested in doing that, they need to do it now.
Well, the other part of this thing that I think is so fascinating and scary is that you said, and I wrote this down, the student loan debt bomb. Did I say?
Yeah.
Which is this massive amount of money that's owed by people that are entering into the retirement years.
Yeah.
And that I would not have expected. I would have still thought, yes, that's the 30s, 40s, maybe. That's it, because maybe you've owned your house long enough, you've been able to refinance it or do something, but still this amount of money that's owed on student debt, and like you said, it's not the person who just graduated, they got their doctorate or their PhD and is going, hey, I want to do that. You said there's a means test. You really have to look at it. But as you're trying to think, and it goes right back to what, one of the main themes of this webinar has been, if you're trying to do something with a parent or a family member, and they have all this debt, it could be student loan debt, it could be medical debt, it could be any kind of debt. The BK process can really help them get out from under it. And this is what is allowed in the law, and people are taking advantage of it. And they're being able to have that much more of an enjoyable stress, and they're reducing a lot of stress out of their life. They're being able to get to what they want to do, living closer to family, or maybe they're being able to discharge it, and then they have a house. You don't have to lose the equity in the property, and you can build the ADU in your backyard. So for your family, because maybe it's reversed. Maybe you're the parent, you want to do the build, but you have this huge debt, but it's like, I have all this equity, I want to tap into it. And we go right back to the wonders of a reverse mortgage. There's hundreds of scenarios where this really makes a lot of sense.
Yeah, I mean, there's people, basically what it boils down to, there's a lot of people who are paper rich and cash poor, and they can't access that equity, that paper rich, because, maybe income wise, they don't qualify, maybe credit wise, they don't qualify. Those are some really real factors that people are dealing with. The other thing, just a quick little tip out there, if you do have an elderly parent that owes tax debt, you can always call the IRS and tell them, can you please put this in CNC status? That's collectible, non-collectible. It means they won't bug you to try and collect it unless you, come into a pile of money. So that's another thing, maybe they don't have the money to do an offering compromise or that sort of thing. And along that line, tax debt can be discharged in a bankruptcy if it meets a 3-pronged test. So definitely get to an attorney about that. You don't have to be living in hiding and, all of that. You can deal with the tax debt, rejoin society. We want you here. We want you spending your money on, on real things. We need that money spent in our economy, not just sending it up the pole to student loan interest or corporations. So
I completely agree with that. So before we wrap up, and thank you very much, Jenny, for all of your time and all
thanks
of your
for having me.
I think it's absolutely fantastic. I'm just so excited that we've had this time together. the questionnaire that you have when you do your free consultation, how long does it usually take somebody to fill that out? Is it 5 questions, 50 questions?
No, it's 11 pages. It doesn't mean you have something to write on every single page. We go through the personal information, the assets, the debts, and the income. And that's really what we're trying to get to the heart of. I would say you're probably going to spend 30 to 90 minutes on it, depending on your circumstances. The number one thing I hear, and I have heard this for many years, is, wow, I didn't realize it was that bad until I wrote it all down. And that's eye-opening to a lot of
Right.
people. So
I would really encourage folks to reach out to Jenny if you're looking for some help. You're in a situation that you don't know how to get out of. You owe a lot of money, or your parent or your family member owes a lot of money.
Yeah.
And you really need to try to examine and look at what your options are. So what Jenny offers and what she was just talking about is a free 30-minute consultation. Fill out the questionnaire. And if you don't want to do that, and you have, $350 to do for that 30-minute consultation, they can do that too, right?
Yep.
Wonderful. Jenny, thank you so much. We're at 90 minutes. I want to be very respectful of your time, because I know you are a really, really busy person. I cannot express how much I've appreciated this, and I hope we can do it again soon in the future.
Thanks for having me. I really appreciate it. Have a great day.
Take care. Bye-bye.